Before I begin, I would like to really thank all my guide, Dr. Milind Umaikar sir, Dr. Vivek Nanoti sir, Dhale sir, Dr. Manju Soni ma'am, Manish Aglave sir, for taking me or making me the part of this webinar in the form of a resource person and sharing my learning with everybody. So I'm really grateful to all my teachers. And with this, I would like to take you through the just beginner or the base of this IPR, because definitely, as I can see, the audience is students, faculty members, research, PhD research scholars, right? So with this, I would like to begin with the intellectual property rights basics, because we are very well aware with the how to protect our property, which are tangible one. But that the intangible properties, which is exactly the invention of our mind, how to protect that the intangible properties, so it is secured under intellectual property rights. So there are different type of IPs. Like most of the time, being a students, we have so many ideas, and being a research scholar as well, we would like to know that at what extent or how we can develop our research work to make it patentable. So that is the reason, first of all, we would like to know what is exactly the basic of IPR. So it is what? It is a creation of your mind. It is created with the use of intellect. Now it involves creation, vesting, and use of IP rights, that is intellectual property laws. So we can protect this IP under the intellectual property laws. So this exactly IP management is not only creating a think tanks, because you are ultimately converting your ideas to the creative thing, which would be having utility for industrial utility, and which would ultimately proactive process for corporate governance, as it is giving economic significance to the country. So as being a voter of India, we generally have a right focus towards India, similarly, or in the territory rights, we can say. So here again, that IP law, under IP law, that rights are for the India. So definitely we can make it at a global level. Again, like how to go through the innovations and how to protect it, that part would be covered by Vijay Shupuje sir. So with this introduction, that what is IP? It is a creation of our mind. So it might be anything, an idea, expression, any type of device, any type of idea. So what exactly the framework of IP law identified by TRIPS and governed by World Trade Organization? So as per Indian IP law, these are the different IP where we can protect our different inventions. So patent is the one IP where we can protect the various inventions, innovations, which is having the industrial applicability, and it is given under the Patent Act 1970. Similarly, we can protect our research work in the form of publication. So that time we can take a copyright for it, for a musical notes, for cinematographic work, for literary work, that we can protect under copyrights. It is under the Copyright Act 1957. Similarly, the next is trademark. You are like, we all have fascination for Apple. We have like for taking mobile phones, or the brand, or we can say the trademark is the one which is giving the identity to Apple, right? So this is the trademark which is protected under Trademark Act 1999. Then comes geographical indications, that most of you are from Nagpur, right? We have Nagpur oranges, and this is a geographical indication we have, and because of it, definitely at some extent, Nagpur is also getting economic significance after exporting of this Nagpur oranges to the outside. So this is again the IP which benefit us. Then it is protected under Geographical Indication of Goods Act 1999. Similarly, we have Protection of Plant Varieties and Farmers Act 2001, where we can protect some hybrid or some biotechnology or some products, that plant varieties we can protect under this act. Then comes to the layout designs of integrated circuit. It's most favorite area of most of the engineering students, that you have to work on integrated circuit, that IC is really different from the one device to the other device. So for that layout designs, that it is protected under the Semiconductor Integrated Circuits Layout Design Act 2000. So you can get protection for the IC. So being a student, if you're inventing or you are designing some different IC and it is having some sort of different mechanism, definitely it would be better than that of the existing one. So that time you can go for the protection under layout designs for integrated circuit. and the one which is not disclosed yet, you feel so this is not disclosed yet, that we can take protection for any of the undisclosed information. And the one which is very booming nowadays, that is design. So the design patent is very well protected under the Design Act 2000. So this is the actual framework of IP, where a different type of are intangible products or process that we can protect under the framework of IP. So this is the organization chart, like the Ministry of Commerce and Industry, Department of Industrial Policy and Promotion is taking care of this all. And for this, the Office of Controller General of Patent Design and Trademark, it is located in different locations. So for patent office, including design, is at Kolkata, Delhi, Mumbai, and Chennai. For Maharashtra, we specifically go for Mumbai. Trademark registry at Kolkata, Delhi, Mumbai, Chennai. Geographical Indication Registry at Chennai. And at Nagpur, we have Patent Information System, that is Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur, through which you can get all the patent information. And it is there in our Nagpur since, I think, since around 15 years before. And even we at SKV is an association with Arjun IPM from long time. So this is the all organization chart. And for taking protection of your any of the IP, you can take information from Nagpur office, which is located at Nagpur. Now, why we are studying this IPR, why I said that even the degree first year and BTech first year students are here, research scholars are here, what exactly it is creating? It is creating an interface between your creation and the right. So definitely you have created something, but as Dhali sir said, it should not be there on a paper, it should have some applications. And definitely if you have created something, it must have some application for social activity, or must be acceptable at social level. So it's the interface between the creation and right. So definitely for your creation, you will get right for the same. Then rights are as an incentives and monopoly. So you'll be having the monopoly for the same, and you'll get incentive for the same for your creation. It foster the innovation as a culture. So ultimately, if we are getting incentive for something, it again gives appreciation to us to do more things. And definitely it foster the innovation as a culture. It is linking innovation to economic development. So as I have told you, definitely if your invention is getting incentives, so it is to the India, and ultimately it is increasing the economic development. Because of this, as it is protected under the IP, definitely it is published through the IP India website, and it prevent or avoid the reinventing by other people. It is also prevent others from exploiting invention. It is prevented, nobody can prepare the same device which is having the same design of any particular company, if I say Apple. So it prevent others from exploiting inventions. Then balancing inventor and consumer. So it create a balance between inventor and consumer. It checks abuse, balances of abuse. It safeguards our traditional knowledge, right? So we have a geographical indication, so we can safeguard it under geographical indications. The structure regime based on needs and priorities of public policy. So whatever the structure of this IP is made in such a way which ultimately beneficial for the public policy. So this is how this IPR is playing role in technology delivery system. Now, as inspired by the session of Nanoti sir, similarly Dhale sir, Maker sir. So this webinars gives inspiration to do something. Right now also, so many of you are having some ideas in your brain that how we can develop this idea, okay? And if it is really worth your feeling, so it is having an inventive step which is not in the existing and will give something new. So that turns to the innovation. Further, this innovation, if you directly post or directly disclose to the public domain, so it would not give you any type of incentives or anybody will going to copy it, right? So before going for the disclosure, we have to protect it under the IP, so that the disclosure through the intellectual property. And ultimately, if it is having the potential right in the market, so it goes to the commercial success, even at India, at local arena, and through the different routes of international filings, we can go for global arena. So this is actually the innovation IP delivery, and it is really important to know how to go with this for students and for research scholars. Now, moving to the first type of IP, this is nothing but a document actually we receive from the government office. And that document, or we can say the patent, describes an invention that creates a legal right under which the patented invention can normally only be exploited, manufactured, used, sold, and imported with the authorization of the owner or inventor of patent. So only the owner or inventor of patent has a right to disclose the invention, to sold the invention, to manufacture and use for the other purpose, right? So this is the document which is very important that we received after a grant of patent from the government office. And the term for one patent or for your one invention is 20 years. So the inventor get monopoly rights or incentives for 20 years after the grant of patent. Now, what are the criteria just to make it patentable? I have used this word more times, that the utility, inventive step. Now, what exactly novelty means? It is new, which is not in the existing, that we have not seen earlier. Okay, it is new, right? So anything that is new, that comes to the novelty. Then comes industrial utility. It would having some sort of industrial utility, yes or no? So that point is really important. The use of your product or use of your process, it is really worth or not. And then last one is non-obviousness. It is an inventive step. That steps make it more applicable, that it is having the technical advancement as well as economic significance. Now, what exactly technical advancement say? So as so many of students like engineering, even we pharmacy students have organic chemistry, right? So we have a synthesis process that A plus B gives C, right? The C product is there. So what we can say, technical advancement. So if you are doing some such a process by which after reacting A and B, you're getting the C in more concentration, or we can say the quantity of C get increased, that process. The process you use for the preparation of C, which increases the yield of C, right? So that time we can call it as a technical advancement. Right. Similarly, as in case of economic significance, if I say, so by utilizing the same funding for taking or buying that A and B reagent, if I'm getting more quantity of C, so initially if I thought I got 10 gram of C or 10 kg of C, and right now I'm getting 20 kg of C because of this process. So it ultimately gives economic significance. Okay, so that is called technical advancement as well as economic significance. So right now here your invention or your product is novel, it is having industrial applicability, and it is having inventive step. So if all these criterias are qualified, then only your research, your invention goes to the patent granted. Okay, so I'm really happy to share this, that we have around 15 patents. From that, 13 patents are published, and 3 are in the examination process. And recently we have received one grant of patent. So this is actually a document which I was talking about, that we received from the government of India, right? So here the inventors of Dr. Milind Umaikar sir, Dr. Gupta, Krishna Gupta sir, and Sonali Askarkar ma'am. She is a research scholar from Srimati Kishore Tagore College of Pharmacy, Kampli. So ultimately, if you are taking your research to that extent, and if you are taking all these criteria in the mind, then definitely the grant is possible, right? So this is again with the guidance of Vijay Puje sir, that we received this grant and efforts of all the professors. So this is how the patent document appears. Now, there are different type of patents. As I've said, process patent, product patent, design patents, right? So process patent. So I think now we have a very well boom of that self-driving car that we can operate by using the app, right? So this is a process which is new. Similarly, 5G, Bluetooth, gene editing sequence. Okay, I'm not saying the gene editing method is the process patent. Gene itself we cannot consider as or patentable, right? So there are some criteria, patentable subject matter. Okay, so as per the Patent Act, this even the microorganisms directly we cannot go for the filing, right? The gene directly we cannot go for filing because they are already existing, right? So but the process is patentable. If the new gene editing technique or gene editing sequence process is there, so that is patentable. Definitely, Shiv Pujya sir will going to throw more light on this part. Then coming to the product patent, so where you have a product like mobile phones, if I say in the pharmaceuticals, we have nanoparticle formulations. Right now, we receive a grant on a product that is Bepostatin, ophthalmic preparation, drone, 3D printer. So for that, where the product is there, for that the product patents are there. And design patents, so here very well known that automobiles, like we know Ferrari, the different cars, Audi, right? They have a different designs which attract people more. Cell phones, that iPhone, right? Then different devices, jewelry. This all comes to the design patent. Even the mobile sanitizers, that during COVID, we have seen so many designs for this, which are designed as per the requirement of phone. So that comes to the design patent. So these are the different patents or different invention, we can say, that we can protect under the process patent, product patents, and design patents. Here in the first two, where process and product patents are mentioned, here it requires a technology enhancement, like more basic research is required here. Now moving to the another IP, that is copyright. So for the expression, not an idea, okay? Procedures, method of operation, mathematical concepts, right? For your computer programs, the title, short words, combination, you can protect it under copyright. It is not protected under the patent. So this literary work, that books, computer programs, your gaming programs, if they're only a program, okay, with software, so that time you will get protection under copyright. Fine. Then comes literary work, dramatic work, musical work, artistic work, cinematographic film related or neighboring rights, sound recording, broadcasting rights, performer rights, that all comes to the copyright. So you can see all these images that comes under or protected under the copyright. Fine. So here for this literary work, dramatic work, musical work, and artistic work, generally plus 60 years of protection is there. Although in case of the remaining four, that cinematographic related work, sound recording, broadcasting right, performance. So after 6 years, that rights that transferred, or we can say the protection is for 60 years. So this is the term for protection of copyright. Fine. But if you have an invention, if you have a software which is assisted with the hardware, right, that time you can go for the patent, right? But for softwares only, you can protect it under copyright. Then coming to the next, this is the trademark, which is the one, the highlighted one, McDonald's. After looking at McDonald's, we generally go for it. So this is what exactly a mark, that is a device, brand, heading, label, name, or an abbreviation of a name, signature, word, letter, or numerical shape of goods, packaging, or a combination of colors or any combination thereof. So we can get trademark for any type of this, but it should represent graphical. This is the first requirement. It should represent graphical. The second, it should be distinctive, capable of distinguishing goods or services of one person from those of another. So nobody can take a same trademark or same graphical presentation for the same good. Similarly, it must propose to be used for trade in relation to good or services. So definitely, if you are using that particular mark for trading in a relation to goods or services, so you need to take protection under trademark. And for trademark, the term is 10 years. Again, you can increase it by further applications. So this is the trademark. So generally, for getting trademark, it requires some time. So initially, if the process is initiated for trademark, so that the product can be labeled as TM, and after registration, once we receive the final confirmation for trademark, so that it is represented as a registered trademark. So this is for logo, slogan, and again, this trademark includes service marks, collective marks, and certification marks, right? So here, if you can see, this Pepsi is a product and the service, right? So which we are seeing from a long time. So for that, the service mark and product mark that is there. You can see ISI, this is a certification mark, right? This is geographical indicator, that Darjeeling tea. This is a geographical indicator. This is again a mark. This is the collective mark that Cambridge University Press is showing, the collective mark, and the logo of Apple, right? So this is the protected under trademark. Here again, as I have told you, the different words, Nokia, Samsung, Tata, Bajaj, they can be protected in this particular format. And again, this particular slogans with IBM, that solutions for small planet IBM. This is again the one that slogans protected under the trademark. And there are different type of what we can say trademark, and it depends on even the shape of, this is the Coca-Cola bottle, right? The shape of bottle and the name, this is protected under the trademark. Here again, the symbol of McDonald M, and this is the slogan, I'm loving it, right? Even the color, different color can be protected, and the logo type, right? So these are the different type of logos, slogans that we can protect under the trademark IP. Now moving to the most important one, that geographical indication, which gives more value to the area, right? And that's why we specifically would like to roam around the different areas of our country. So here you can see here the notice or document again, which notifies that the product originates from a geographical area, which could be an agricultural product, an industrial product, a food product, right? So this method of IP protected by a decree or by a register. So there is a register in the Controller General of Patent and the Trademark Office, where all the things are mentioned, which are protected under the geographical indication. So what it gives, or which type of information it provides? So it gives, it informs consumers about the origin of the product. So like basmati rice, Vellore, right? So this particular gives the origin of the place. Similarly, Kanchipuram sari rice, right? So that gives the origin of the product, the consumer. Again, it protects consumers from deceptive goods or products, like the different products belonging to different area, right? Then to the market, protect the market of producers. That definitely we get more Kolhapuri chappals and from the Kolhapur, and it is associated with that particular area. Similarly, it promote the economic prosperity and a fair share of product and goods of a region which enjoys the reputation. So ultimately, these are all the different type of geographical indications, agricultural products, industrial products. Then again, you can see mangoes, here Alpanzo, right? Nagpur oranges. So they all are protected under the geographical indications. And again, initial term is 10 years, and we have to renew it after 10 years for continuation of a geographical indication. So this is the most important area of IP. And this is the most important nowadays, that industrial design. It is an industrial design constitute an ornamental aspect of article. It is necessary that it should have the ornamental aspect of an article, and this design must have a three-dimensional features, right? And such a shape of an article. Here you can see the shape of this crusher for crushing of coal, and two-dimensional features such as pattern, lines, and colors. So ultimately, it gives a design number, and it is again having a term of protection for 5 years. So this is what all about the different IPs that where we can protect our invention, our ideas, our expression, even for the location-wise, geographical indication, and industrial design. So with this, I think this is just a basic of IPR. So lastly, I'm taking to the last, this sort of just a recall of all this lecture, right? So what exactly IP means? IP is what? It's a creation of your mind, right? It's a creation of your mind. It might be invention. This is a stethoscope. It is an invention. It is a device, and it's having a medical application, right? So this is protected under patent, right? So any invention is there, that the product or process that is protected under patent. Now you can see the books, artistic work, musical notes, cinematographic work. This work is protected under the IP copyright. Then the logos, slogan, particular design of logo is protected under the another IP, that is trademark. Then comes the label design. It is again coming under to the copyright. Now this is the industrial design of, or industrial design or design patent, where we can protect the design. And the most important one is the Nagpur orange, we can see here, that is geographical indication. So we can protect it under the geographical indication. So this is what all the intellectual property, we can protect our invention under any of this IP. So with this, I have clear with the basics of IP. I hope students understood where we can protect our ideas or expression or our invention. So with this, I'm really grateful to all this, the references, WIPO website and all, even the NALSAR faculty members for their guidance, as well as Vijay Puje sir for this. And with this, I'm really thankful to all the organizers, all my teachers and all my students. Thank you.